You just got hurt at work. Your back is on fire. Your boss is telling you to tough it out or just file it next week. And right now, a clock is already ticking, a clock you can't see. And if you don't do the right things in the right order, the insurance company will use every single mistake against you. I'm Ken King. I'm a workers' compensation attorney in North Carolina, and I've sat across the table from insurance adjusters who denied someone's entire claim because of one simple thing they didn't do in the first 48 hours. I don't want that to happen to you. So here are the 5 things you need to do immediately after a workers' comp injury in North Carolina. And I'm going to tell the exact order to do them in. It's important. The very first thing, and I mean before you do anything else, is report your injury to your supervisor. But here's what most people get wrong. They tell their boss verbally. They walk up. They say, "Hey, I hurt my back on the loading dock." And the boss nods and says, "Okay, we'll take care of it." 3 weeks later, the employer tells the insurance company they never heard about any injury, and now it's your word against theirs. Under North Carolina law, that's General Statute 97-22, you have 30 days to give your employer written notice of your injury. 30 days sounds like plenty of time. I can assure you that it is not, because the insurance company isn't counting from when you report it. They're counting from when they can prove you reported it. So here's what you do. You write it down, an email, a text message, even a note on a piece of paper that you photograph with your phone. Date it. Keep a copy. You want a paper trail that no one can deny. You'll need it in court. And I know what you're thinking. I don't want to make a big deal out of it. I don't want to get on my boss's bad side. I understand all of that. But here's what I've seen happen over and over. A worker doesn't report it in writing. The injury gets worse. And by the time they need surgery, the insurance company says, "This didn't happen at work. There's no record of it." That one text message to your supervisor could be worth tens of thousands of dollars to your claim. Now, I'm going to come back to this idea of protecting yourself from the insurance company in a few minutes, because step number 4 is something most people never see coming. Second most important step. Get medical treatment and make sure you say the magic words. And when you do, you need to say 5 very specific words to the doctor or the nurse. This is a work injury. Why does that matter? Because your medical records are the backbone of your entire claim. The insurance company's lawyer was going to read every single line of those records. And if you walked into the ER and said, "My back just started hurting," without mentioning work, that's a gap. And the insurance company will try to drive a truck through that gap. Now, here's a question I get all the time. Should I go to the emergency room or urgent care? If it's a true emergency, you can't walk, you're bleeding, something is broken, go to the emergency room. But for most injuries, urgent care is actually better for your workers' compensation claim. Here's why. The ER is fast, it's chaotic, and the notes are often thin. An urgent care doc is more likely to document your injury thoroughly and connect it to your work activity. Either way, the ER or urgent care, tell them exactly what happened. "I was lifting a pad at work and felt a pop in my lower back." Be specific. The more detail in those medical records, the harder it is for the insurance company to argue it didn't happen. And while you're there, ask for copies of everything, every form, every note. Start a folder, physical or digital, because you're going to need it. Step 3 is the one most injured workers in North Carolina don't even know exists. It's called Form 18. Form 18 is your official notice of injury to the North Carolina Industrial Commission. It's simple. One-page form. You can find it on the Industrial Commission's website at ic.nc.gov. You fill it out and you file it. Now, your employer was supposed to file their own form. That's a Form 19. But here's the thing, and it's important. You cannot rely on your employer to do their part, to do the right thing. I've seen employers forget to file. I've seen them file it late. I've seen them file it with wrong information. File your own Form 18. You have 2 years from the date of your injury to file it, but do not wait. File it now, this week, because this form creates an official record with the state of North Carolina that you were hurt at work on a specific date. Unless it's filed, it's very hard for anyone to pretend your injury didn't happen. Remember what I said about protecting yourself from the insurance company? This is your next layer of armor, but there's one more thing coming, and this is the one that catches people completely off guard in many cases. Do not give a recorded statement. Not yet. Within a few days of your injury, your phone is going to ring. It's going to be a friendly voice, someone from the insurance company. They'll say something like, we just need to get a few details so we can get your check started, so we can process your claim. And then they'll ask, do you mind if I'll record this? This is not a casual conversation. This is a recorded statement, and everything you say can and will be used against you, or in workers' comp, to deny or reduce your benefits. The adjuster is trained to ask questions in a way that gets you to say things that hurt your claim, even when you're telling the truth. When you have any back pain before this happened, have you ever been treated for back problems? Could this have happened outside of work? You were not legally required to give a recorded statement. I want you to hear that again. Under North Carolina workers' compensation law, you do not have to give a recorded statement to the insurance company. You can politely say, I'd like to understand my rights before I give any recorded statement. That's it. That's all you have to say. This one step, just pausing before you talk, can be the difference between a claim that gets accepted and a claim that gets denied. I've seen it happen more times than I can count. Step 5, and this is one that protects you for the long haul, document everything. Take photos of where you got hurt. If there was a spill, a broken piece of equipment, a missing safety guard, photograph it. Use your phone. Today, because tomorrow they might be cleaned up, fixed, or gone. Write down the names of anyone who saw what happened. Co-workers, supervisors, anyone. Get their phone numbers if you can. And most importantly, start a timeline. Date of injury, who you told, when you went to the doctor, what the doctor said, when you filed your Form 18. Keep it all in one place, a notebook, a folder, on your phone, whatever works best for you, but document everything. Because here's what happens 6 months from now. The insurance company is going to question your story. They're going to look for inconsistencies. They're going to compare what you told your doctor to what you told your boss, to what you told the adjuster, to what you told your friends or coworkers. And if your details don't line up, not because you're lying, but because memories fade, they'll use that against you. Your documentation is your shield. The more you have, the stronger your claim. So those are the 5 steps. Report it in writing, get treatment and tell them it's a work injury, file the Form 18, don't give a recorded statement without understanding your rights, and document everything. But here's the thing. Now that you've reported your injury, the insurance company is going to call you. And there are 5 things they're hoping you'll say. 5 things that sound completely innocent, things you'd say in your normal conversation. They can absolutely wreck your claim. I break down all 5 in my next video. You're going to want to watch it before that phone rings.